thank you very much for the floor. It's great to be back here behind this podium and actually to see many familiar faces. Maybe it's a little family, the family dealing with posting at European level. So we met several times. Thank you for coming, and also thank you for the invitation, above all to CNCE and Fondazione Brodolini. Mr. Carapella requested me to have my speech in Italian. I'm sorry very much, but it's okay for me because if I correctly understood, there is a problem of circulation by means of YouTube of our speech, so it would be easier in the next future to circulate in Italian and avoiding translating and something, you know, like a subtitle of my speech. However, the slides are in English, and I will try to switch a little bit. So sorry very much to the interpreters. I mean, you know, okay. Just few lines of introduction. My time is really limited. I'm going to start less than 10 minutes because Feliciano overlapped everything. Was very good, his introduction, but you know, I will try to restore the good order. My idea is to offer today the main points of my ongoing reflection, investigation on this matter. I began some years ago in Leuven during my LLM program to study these matters, and I understood more or less 20 years ago, but now I'm really convinced about that in order to face with the problem related to posting, we should implement only a pragmatical approach. No way for a theoretical approach. There is no way of solution. So pragmatical approach first. Second, I'm totally convinced that the solution is a European solution, is not a domestic solution. So what we should do is to find something that is a European solution, that is a sort of regulatory attitude that could conduce to a full justice for everyone that is involved in this phenomenon. Bene, allora...
Fine. In these 10 minutes, and I'll ask Feliciano to tell me when I'm nearing 8 minutes. I will explain, that's the right penitence he has to pay. So I'll explain my approach to the topic of posting. As you can see, the title is rather emblematic. I'm just asking myself whether less or more posting is better, and whether the recent directive, the 2018 Rev D, the revision directive, is enough, or whether more needs to be done. So my presentation will be divided into two parts. One, the first part, the first section, which is a bit boring, and this is the approach of jurists, and I apologize to those who are jurists, but it's necessary to justify the solutions I'm putting forward. And then a second section, which is very short but very interesting, because I'm going to put forward my current reflections on the relationship between posting and technology. And shortly, I will be publishing an essay on how blockchain can help manage posting at EU level. And I believe that the solution to posting involves the use of this blockchain technology. I will shortly be telling you in the course of these famous 10 minutes. I'll be talking about these two different aspects. So the fundamental question that we've been asking ourselves since the 1997 directive was introduced is how much labor protection should the host state provide to posted workers. So this is a huge problem, the problem of how much, because we need to measure protection to obviously monitor the various legal institutions that need to be applied to posted workers. And when we think about this aspect, all the jurists who deal with these matters, both scholars, judges, and those operating in courts and in institutes such as the funds, are faced with this issue of Article 3, which is the problematic point, but from my point of view, the actual solution to the problem. That's, however, where we need to focus our attention. So, how do I normally analyze and how do I suggest the analysis of this conflict between the Posting Directive, which I will refer to as PWD for shortness, and the treaty, because the issue of Article 3 is the conflict between the directive, which has evolved over time, and the treaty. So from my point of view, there are three models of application of this conflict. One first model, according to which only in some cases only the directive applies. In a second model, is that the directive is applied, but it needs to be reviewed in accordance with what is provided for Article 56 of the treaty. And this is, we have had all the issues with witness and the past years. And then the third model, and I will insist more on in this 1.5 minutes that I have available, namely the directive applies, but since the directive leaves matters to national law, we are left with the issue of the compatibility of national law and the article of the treaty, Article 56. So that's the issue. So how did we jurists try and explain these three models? Let's start off from model 1. So only the directive applies, namely, well, we know that this is not a fact in reality because the directive is not aimed at achieving harmonization. It is aimed at harmonizing procedures, but not contents, i.e. the protection that needs to be applied to workers. Model 2, instead, raises a number of complications. Here we had a case, the Hendricks case at the Court of Justice, that created a number of complications for us jurists in developing the notion of compatibility with the treaty. The application of these two models tell us that we do not fit entirely in Model 1, i.e. the model according to which only the directive applies. In Model 2, we have the directive applies, but we have to have a revision in the light of Article 56. And in Model 3, and I'm using a picture of the sea because it's open up some horizons, the real issue arises when we're faced with Model 3. This is the issue, and I said it in English before. It's a vexed question, because even though since 1996 to 2018 we've had directive studies, gaps analysis, analyses, we've had everything that we could have had, we can't solve the problem entirely. Not because we are unable to do so, but the lawmaking technique that derives from the directive and Article 56 is putting us face to face with this issue, namely where we have the area of harmonization. Let's think about Article 3 of the directive. There is a reference to domestic law, which means that there is a reference to matters of substance, of notion. Let's think about the concept of wages or remuneration, or until a short while ago it was minimum rates. So we leave it to national states, and that is the fact, to define remuneration. It's clear that every time a state will take one step forward in qualifying these institutions, we might be faced at the Court of Justice there trying to justify this choice. So we're in a sort of paradox, if you think about it and you observe things carefully. And I'm going to say this in English to the benefit of our European colleagues. And this could be perhaps clear without obviously discrediting the wonderful work that the interpreters are doing. From my point of view, and I've written it here, and I hope it's clear.
States insist to what constitutes pay remuneration is a matter of national law and a question of national competence, the more, in my view, of their decisions are likely to be subject to the view of Article 56. E ovviamente questo significa teoricamente violare.
So this means violating the treaty. Now, this means obviously leaving it to the court to decide on the definition of wages. So we are forcing the court to say whether there are institutions that have to be considered as being part or not part of wages. I've tried to just mention a number of things in this slide. So sick pay, maternity pay, unfair and dismissal compensation. In the Italian case, we have the huge issue of contribution to joint organizations. The case of Bolzano has not solved the issue. It has provided some guidance, but it hasn't solved the problem entirely. So, since we are faced with a problem of this nature, the directive has to be built by referring to national law and therefore to collective bargaining. And so it's left to states to define the contents of what is protected and what protection consists of. And the court can check in accordance with Article 56 if there is compatibility with one of the fundamental freedoms, one of European freedoms. We have to find practical solutions. I think there are two. One I mentioned in our previous meeting last year, if I'm not mistaken. At the time, I put this forward. I'm still working on this, and I think that France is moving along the same lines, and even some European political parties during the near elections are moving along the same line. So the idea is that, as in the United States, when workers move within the framework of geographical mobility from one state to another, there is the power to define minimum wages tied to geographical mobility. That's what we need to do in Europe for all geographical mobility within the EU. So, in other words, we have to impose on state to define by law for those countries that don't have minimum wages fixed by law, to define minimum wages for the purposes of the posting workers. So this means that there is a law on which all the elements making up wages can be based on. But this is a huge political issue in many countries, including our own, where we are unable to achieve this goal of defining minimum wages by law. The other aspect I'd like to insist on, and I'd like to bring up as a main fundamental idea as we're working, and I'm referring to also to an essay that I'm about to publish shortly. I have proposed, and I'm reasoning about the idea that posting, any type of posting, needs to be backed by a European blockchain network. Blockchain is an advanced technology. Europe is investing millions of euros to extend the blockchain to the public administration. It's a model of certification, mutual certification amongst players that are associated within a digital network with mutual recognition. It is a mechanism that is already being used in some states, for some administrations, for healthcare, education, for example. So we could consider using it for the enforcement system, and so everything that is tied to geographical mobility has to involve the blockchain network managed at European level. This would mean that what is excluded from this network is easier to monitor and check, and therefore it would be easier to apply sanctions. Blockchain has immediate strength because it makes everything visible and transparent concomitantly. So blockchain means that any player tied to that network, be it a posting company or a posted worker or an inspectorate, funds, can concomitantly see what is happening in the professional life of that worker at that given time. Technology allows us to do this. Technology is not an obstacle. So, from my point of view, it's a pragmatic solution that we need to pursue to overcome the issues that will be dragging along with us, despite the huge progress made in European legislation over the years. Thank you very much.